Good afternoon for everyone on call. Mic testing. Can you hear anything that I am saying? You can raise your hand if you can hear me, or just respond. Can you hear me? Good afternoon, everyone. My name is Wendy Muganda. If you can hear me, please raise your hand so that um, I can adjust accordingly. If not, thank you, Job. I've seen your hands. Thank you. So let's give it like 5 minutes so that we wait for more members to join, then we can start. Thank you. Thank you everyone for your patience. For those who joined late, my name is Wendy Muganda. Thank you for joining. My name is Wendy Muganda, the Programs Manager at LSK Nairobi branch. I would like us to start the session. And before we do so, I'd like our chair to give remarks. Our chair of Nairobi branch, Eric Kivuva, followed by chair of Mount Kenya, Mr. Joel Mutuma. So, Chair, I will allow you to speak. Chair, you can proceed.
Very well. Thank you very much, Wendy, for starting us off. I'd like to just take this opportunity to thank the teams that have been behind these collaborative efforts that is aimed to look at the legislation that is amending our laws, the laws that basically dictate how we practice. And so I want to thank the teams from Mount Kenya, the teams from the Nairobi branch, and say that we really appreciate the effort that you've put in to just go through all these pieces of legislation and your willingness to take us through this. I'd also like to welcome our members from Mount Kenya, members from the Nairobi branch. This is just the start of many other collaborative efforts that we will be putting in place as the two branches to ensure that there is more cohesion and interaction between our members. So karibuni sana and thank you very much.
Thank you so much, Chair. Chair Mutuma, are you on call? I think we will allow Mr. Mutuma to give his remarks when he joins. So we go straight to the review of the Advocates Act, the Advocates Marketing and Advertising Rules, the Advocates Disciplinary Committee Rules, the Advocates Practice Rules, and Mount Kenya will tackle Law Society of Kenya Act 2014 and the Law Society of Kenya General Regulations 2020. So we will start with a presentation from Oyo. Oyo, if you're on call, I will just allow you to speak. So Wycliffe Oyo is a council member at LSK Nairobi branch, and he will be taking us through the Advocates Marketing and Advertising Rules 2014 and the Advocates Disciplinary Committee Rules 1990. Oyo, are you able to speak?
Yes, Wendy, I am able to speak. Can you hear me?
Yes, I can hear you.
Thank you very much. So thank you again, members and Chair Kivuva, Chair Mutuma, the secretariats on both sides. And I believe we have fellow council members as well on the call, particularly Efishila and Doni Gashara, who will also be taking part in this initiative. I had hoped in his introduction, Chair Kivuva would have said something about why we are conducting this exercise. He hasn't, and with his kind permission, I'd probably want to start there if that is okay, Chair.
Please proceed, Bwana Secretary.
Asante sana. So as introduced, my name is Wycliffe Oyo. I am a council member at the Nairobi branch and also the secretary to the branch council. And basically we have, as the 8 branches of the Law Society of Kenya, had a call from the main society asking that through our membership, we give comments and views on various pieces of legislation touching on practice with a view to proposing amendments to those pieces of legislation, and also getting feedback as to whether indeed we are being served by those pieces of legislation or not. And the Law Reform Committee of the Law Society will definitely collate these views, and we hope that through this engagement and other engagements elsewhere, then there will be amendments to some of these laws that will impact on how we practice and probably make it better. We also hope that the membership, because this is the reason why we are here, will have a serious input in terms of comments, observations, and whatever it is that they may want to say with regard to some of these pieces of legislation, and that will enrich the discussion. I am informed by Wendy, and I have no reason at all in this life or the next to doubt her, that this webinar or this meeting is being recorded. So if you find an opportunity to speak as part of your contribution, that will be fine. We will have the transcript prepared of the recording. If you find an opportunity to engage in the chat section, that's also okay. We will collate all these views once we are done with the presentation. So for the council members who will be taking charge today, it's not really us doing a training. It is just walking us through some of this legislation and just pointing out areas of concern and points of discussion that we may think would provide useful guides to this conversation this afternoon. We may also need to indicate that conversations around other pieces of legislation may have happened elsewhere and could possibly be at an advanced stage, particularly the issues regarding the amendments to the ARO. Some of you may have seen presentations around the same, including at the annual conference in last month. So we have to be alive to those conversations that are happening, and to also mention that this is not the last of the engagements that we are going to have. So let's continue conversing. Let's treat this as a continuing conversation. Chair Kivuva, Chair Mutuma is on call now. Do we have him have his remarks before I continue, or should I just continue? We can have your directions on that. When the chair is muted, can you hear me?
Yes, I can hear you. I've given speaking right to Chair Mutuma.
Yes.
Chair Mutuma, can you say something? Are you able to speak?
Yes. Hopefully I can be heard.
Yes, we can hear you.
Yes, apologies. I had a problem, a hitch joining, but I'm grateful for this opportunity. I'm Joel Mutuma. I'm the chair LSK Mount Kenya branch, and I'm also grateful to the members of Nairobi branch for this initiative where we are collaborating together to discuss the various acts that affect the advocates. We are ready to dig in, and I'm grateful that we shared the responsibilities. For Mount Kenya will be represented by Hiram Kirimi, who serves as my treasurer in council, and Margaret Kimani, who serves as the deputy secretary in my council in Mount Kenya. Thank you, and God bless you all as we engage. Thank you.
Wendy, I believe it's now safe for me to proceed.
Yes.
I wouldn't have wanted to proceed before my chairs both speak. Thank you, Mr. Mutuma, for joining us. So I'll be taking us through two pieces of legislation. That is the Advocates Marketing and Advertising Rules 2014 and the Disciplinary Rules of 1990. It's called the Advocates Disciplinary Committee Rules of 1990. So just to quickly dig in because of the passage of time, the advocates' marketing and advertising rules have the purpose of having the framework or preparing the framework governing legal practice on advertising by advocates. And we seek to have members engage by sensitization of what these rules are about, highlighting the practical challenges we think are in these rules, and inviting proposals for reform. We think this is important because these rules impact on professional ethics, public interest, and what we now term as the modern realities of practice, which I believe is the overarching theme in the review of all these legislations that we are talking about. Now, by way of just a brief introduction, those of us who may have interacted with the issue of advertising by advocates before may be aware of the Okenyo Mwanza case that challenged the total ban on advertising by advocates, and that petition succeeding, I believe, sometime in 2014, then led to an amendment in the law and the promulgation of these advertising rules in 2014. These advertising rules may still not completely deal with the issue of advertising, because the very nature of the rules are that they are still very restrictive in terms of allowing advocates to advertise. So we think while the ban is lifted and advertising is allowed, there is still a sense in which the rules are quite limiting. For example, the rules say they prohibit unprofessional advertising to ensure that the professional dignity of our legal profession is upheld, and that they allow factual and objective communication of services. For example, just the advocate putting out their name, address, qualifications, and practice areas. They also seek to prohibit touting, giving of misleading information, or self-laudatory statements, and they restrict advertisements on billboards, media adverts, and online promotions. As we may have seen elsewhere, particularly in other jurisdictions, the advertising, for example, in the United States, maybe not a Commonwealth jurisdiction, could be a you would say mixed jurisdiction, is more prominent, including on billboards and such other media, and that is not allowed here. And we think there are practical issues then that relate to these rules. And one of them is the ambiguity in the definition of some of these terms. For example, when they prohibit someone from self-lauding, what does that term self-laudatory mean? How does it, how do you advertise without, for example, is it chest thumping or just bringing out what you think are your best attributes, and how far can you go with that without it being, deemed to be self-lauding? It also talks about things like dignity of the profession, and dignity of the profession is not defined in the rules or in the act. So it remains a subjective matter that then the advocate has to, at every point in time, look at and determine if the manner in which they are advertising indeed upholds the dignity of the profession or not. The second issue is with respect to the applicability, or even, in fact, even the relevance of these rules in the digital era. And if you heard me clearly, the rules are 2014 rules, and it is no doubt that between 2014 and now there has been quite massive technological advancement and developments, including even in the way we do court now. The virtual platform is something that I think came after the enactment of these rules. So we believe there are issues that relate to how relevant, how modern are these rules in light of social media use, websites, online platforms, and these other areas that now continually attract marketing and continually also attract business for advocates? For example, would it be okay to put out information in a certain manner on IG, in a certain manner on Facebook, TikTok, and such other fora? The third issue we pointed out with respect to these rules are about competition versus access to justice, and the very philosophy behind the court allowing the advertising, at least in a restricted manner, was to ensure that members of the public are able to engage with and access legal information, but also legal services from advocates. Traditionally, the thinking behind the ban on advertising was, for example, that an advocate would get work from reputation, that then you would have repute as a major method of landing clients and probably referral from your clients who've seen how good your services are. But is that the reality in now a very competitive environment we find ourselves in, and where life is now lived probably on the front foot in terms of just on social media and elsewhere? Is it also the case that say Article 46 of the Constitution on consumer rights is impinged on if we do not allow more broad advertising as opposed to this restrictive means? If you consider it against the backdrop of, for example, the LSK saying clients now can go to the portal, for example, to check if their advocate is active, that it is no longer just the advocate's fault if he doesn't take out a PC. So there is a sense in which we have desired that clients take up a more active role in who their legal counsel is, how they interact with their legal counsel. Would it not then be also proper that these same clients can then be in a position to have much more information regarding the provision of legal services without offending the rules of professionalism in our profession? Lastly, we looked at the issue of cross-border practice. I think, again, this is something that has come up, especially in our engagements with our regional counterparts, and particularly under the banner of the ELS. You may find that if you look at firms that, for example, have a group, a network, and I believe most firms are now going towards that route of being the Bowmans, the CDH, the Lex Africas of this world. If in that conclave, then there is allowance of other jurisdictions to advertise in a manner that is not allowed in Kenya, issues of competition, issues of matching up, issues of market imbalance and market standards may arise that then may probably disadvantage a local firm compared to an attorney in the US who would just put out all the information out there and then angling for the same piece of work, for example, with us. So out of those points of concern, we thought then we may have the following as points of discussion regarding the rules. Number one is to ask whether the 2014 rules are too restrictive in light of social media and digital platforms. Number two is whether there should be clearer guidelines on permissible online advertising, for example, on X, on Instagram, on LinkedIn, and such other platforms. Number three, should we allow comparative advertising, provided, for example, that it is truthful and evidence-based? We had in the year gone or before an issue of someone who was being accused of masquerading. And one of the things that the media ran with was that he had 126 cases. We don't know if that is factual or not, but if you've actually 126 cases, and that's a matter of fact, should you not be allowed to put that out there so that who has 1, 2 can then not claim to be on the same pedestal. Number 4 is, should there be caps on what may be advertised? For example, there is a prohibition on advertising success rates. Currently, you cannot promise success in advertising. Should that be the prohibition? Should it continue? Should there be, specialization? Can you advertise on how much fees you charge, provided, for example, that it is within the bounds of the ARO? How far then can we go? And lastly, how do we balance the ethical concerns with the needs for lawyers, especially younger lawyers who may want to build a brand, who may want to become more visible, and just to participate and compete in a fast-changing technological world? Those are some of the issues we picked out. Probably we can have interventions, so we can have questions which can be taken by anyone, and then we can proceed to the next. Wendy, I believe that's the preferred method, or could we do the two first before we take interventions? I'll defer to your guidance.
Thank you, Oyo, for that brief report you've given of the 2 pieces of legislation. I think it would be best to take comments or questions before we move on to the next.
Thank you, Wendy. I believe you can guide that process.
Yes, if you have a question or a comment, please raise your hand and I will allow you to speak. Chair, you
When
trying
is
to
the
say?
chat enabled?
Yes, the chat is enabled.
Thank you, Wendy. Members can also put their comments in the chat or questions.
It seems there's no question or comment about the 2 pieces of legislation. I will just give it like 1 more minute in case there's anyone who's joined late. We have received a presentation from Wycliffe Oyo on the Advocates Marketing and Advertising Rules 2014 and the Advocates Disciplinary Committee Rules 1990.
Wendy, I'm yet to tackle the disciplinary committee rules. I've just done the advertising rules.
Apologies for that. So if there's no comment, then I think we can move on to the next one.
Very well. I think in the interest of time, we can move on then when, or if there are questions, we can handle them as and when they come. So thank you. So the second one and the last I'm handling is the Advocates Disciplinary Committee Rules 1990. And this particular one, the dreaded issue for me is the 1990 reference. I believe over 75% of the current membership of the Law Society of Kenya were not born in 1990. That is how badly, from where I sit, these rules need a relook and an upgrade to conform to modern realities or the present day realities. So some of the key provisions of these rules, they seek to establish, or they actually do establish, the procedure for handling complaints against advocates, the lodging of those complaints, service of documents, hearings, and penalties. The committee is also empowered to censure, fine, suspend, strike an advocate off the roll, and such things as may be within its power. And if there is a party that is dissatisfied with the decision of the ADT, then appeals lie to the High Court of Kenya. In recent weeks and months, we've had, for example, decision that came from the ADT regarding a senior member of the profession, which decision regarded the use of social media and the publication of matters on social media that would be deemed to offend professional ethics and professional bounds. And I think apart from the noise that was made about that decision, it's very interesting that that decision was made currently in light of the rules and in light of the provisions of the rules which predate most of the modern engagements, including the Constitution of Kenya 2010. And that is the first practical concern we have about this, that right now we have a robust framework for the protection of fundamental rights, and of course the evolution of what would then also amount to professional ethics and standards. And in particular, if you look at pieces of legislation like the Fair Administrative Action Act, that has sort of even revolutionized what fair administrative action looks like, if these rules are to predate such kind of legislation, then it begs the question whether they could actually competently cover what is the present day best practices without the lacuna falling in the hands of the ADT, to sort out. For example, I perused the rules, and apart from members of the ADT who are, for example, elected by the Law Society of Kenya membership, they do not provide for a self-check on the members of the ADT. This is a very bad example that I am going to give, but a sitting member of the ADT, for example, has had a criminal case filed against him and has taken plea in a matter that is ongoing. Indeed, the presumption of innocence prevails, but the rules do not contemplate such realities of a member of the ADT sitting as such would also, be finding themselves in trouble with the law. I think also a few weeks ago, the then chair of the ADT resigned, privately citing a lot of frustrations with the mechanics there, including the efficiency of proceedings, backlog of cases, delays in conclusion of the proceedings, and issues like that, which is also a practical concern for us. But also citing issues related to how this ADT should, relate with the LSK, and just how much, input should members have, how much scrutiny should members have on this, and how pious would then be our members who are sitting at the ADT. There is also the issue of the backlog of cases, as I've mentioned, and if you've interacted with the ADT in any manner, you may already know that even taking plea is not an easy thing there. To get a member to take plea, that would have been deferred so many times, and there is backlog of cases, there is technology and the limited provisions, for example, on e-filing, virtual hearings, digital evidence, and such like issues. And I think at some point we just used to cram at some small place. I believe it was at the professional center or somewhere, where there would be so many matters that would not have received attention in good time. Then there is also the issue of transparency and fairness, especially as regards public awareness of the process. And indeed, the major people who would complain about our membership would most likely be members of the public. In my instruction by the Venerable Elisha Ongoya, he opined that in this practice, probably the only enemy you have before you get other enemies is your client, because this is the only guy who is probably going to report you to the ADT or to the SEC. And how much then the public knows of this is an issue that may need much more sensitization, much more thought, and maybe better rules to deal with that. The other issue is the sanctions, the fines and penalties, not reflecting present day economic realities, definitely because of the time when they were set and just how much the dollar has been beating us. And there is also the issue of the composition, and the AG's office, I believe, is still a major factor or a major player in the composition. Therefore, if there is executive involvement, it may not augur well with the principle of separation of powers, for example. And I think those are issues that then lend themselves for discussion. So some of the points of discussion then that arise from this is whether we should modernize the rules to align with the FAA and the Constitution. For example, Article 47, the right to fair administrative action, Article 48, the right to access of justice, and other enabling provisions of the law. Number 2 is how do we address backlog and ensure faster resolution of complaints. Number 3 is should we then have them also incorporated in the e-filing portal? So if that has not happened, and then adopt digital filing and maybe virtual hearings, I think have appeared before them virtually sometime in the recent past. Number 4 is should penalties and fines be reviewed upwards to deter cases of misconduct, or what other strategies then can we adopt to ensure that it's effective? And what is the balance that can be struck between protecting the public and safeguarding advocates from frivolous complaints? Because I think that's a big one in the wake of everyone just knowing or thinking that they know the law. Very many complaints are made against advocates now, where the rallying call is that wakili amekula pesa yangu, and especially when we have practices like contingency-based practices and RTA and such like matters. We are now doing RTA also in employment, and the propensity of the client to want to report the advocate if they think that certain agreements have not been actualized. Then how do we also ensure that there is a screening process for the complaints that come to the ADT? So those are some of the issues we identified, and we welcome members to also weigh in. From my presentation, I think I have maybe 1 or 2 cross-cutting issues for both sets of rules, including whether there is need for harmonization with emerging laws such as the Data Protection Act, the Competition Act, and generally the Constitution. Number 2 is how do we then adopt international best practices, even as we strive to maintain professional dignity. And number 3 is balancing access to justice vis-a-vis self-regulation of the society, so that we don't also allow, or, the society to run away from us in terms of regulation. I think these are some of the issues that we'd prefer member feedback to know what should be prioritized, and maybe just also talk about your experience with the rules, challenges, benefits, and what members think could be done to enhance their relevance in today's practice. I thank you, my chairs, and I thank you, Wendy, and I return it back to you.
Thank you, Oyo, for that presentation. Just going through the comments, I can see Ronald Onyango wrote, I'm both an advocate in Kenya and solicitor practicing in the UK. It is possible to stay compliant within defined advertising regulation framework and still be able to advertise legal services. The same approach is ably utilized in the UK by solicitors who follow specific guidelines would be considered. So that is one comment we've received. This is in relation to the marketing and advertising rules. If there's anyone else who has a comment or question regarding the said rules and also the Advocates Disciplinary Committee rules, you can type in the chat section or just raise your hand and I will allow you to speak.
Wendy, if I may.
Yes, Chair.
I just wanted to react to something that the Secretary has raised on the issue of screening matters that go to the ADT. But Secretary, I don't know whether you had an opportunity to look at other jurisdictions or the best practices. Is there a jurisdiction specifically that has that screening? Because I note that there are quite a number of matters that go to the ADT merely to embarrass our members. And so are there recommendations that you may have picked from other jurisdictions?
Chair, I was looking at the bar in England and Wales, and I think while it's not screening in the strict sense of it, the bar is higher as to the nature of complaints, but definitely it's an area we can explore to see what other jurisdictions are doing, and also to just take into consideration the uniqueness of the Kenyan and just how litigious we've become, especially post the enactment of the Constitution, where we seek to try and ventilate our issues in court, for example, as opposed to preferring ADR mechanisms for that. I mean, Chair, you have seen in the recent days, it's not even a litigant who has issued a demand letter to a judge. And these are things that are, I call them uniquely Kenyan. So I think we may respond to it with comparative study, but also taking into account and having in mind who we are as a people. Thank you, Chair.
Anyone else with a comment? If you'd like to share your written comments after this session, please send to info@lskenairobi.org. I'd share the email address on the chat section. I can see your comment, Ronald. There is need for harmonizing Advocates Act with Data Protection Act. The Advocates Act needs to have clarification on acting for clients where their matters cut across more than one jurisdictions, like cross-border matters, and the transfer of data between two jurisdictions has previously caused concerns. This is well noted, and if there's no other comment or question, then The next presentation will be from Effie Sheila, and she will be handling the Advocates Act. Effie, if you're on call and you can hear me, you can unmute. Effie?
Hi, kindly just allow me a few minutes. I'm having network issues. Just a minute.
Muthoni, are you on call?
Yeah. Wendy, can you hear me now?
Yes, I can hear you. It's okay.
Sorry?
No, it's okay. Proceed, Effie.
Please put up the presentation.
Okay.
Well, I hope we can all see. So I will start with the reviewing the Advocates Act, Cap 16. So the first part that we're going to look at is Section 12 on admission as an advocate. It states that when the hope I can be heard, I'm having network challenges, but I hope I can be heard. Can I proceed?
Please, Effie, we can hear you.
Thank you, Chair. So qualification for admission as an advocate, subject to this act, no person shall be admitted as an advocate unless he's a citizen of Kenya, Rwanda, Burundi, Uganda, or Tanzania. I think one of the issues that we have been looking at and have had in the recent past is the issue of reciprocity, where we've had our borders closed or borders from the neighboring countries closed, as opposed to accessing the becoming of an advocate in Kenya. So one of the things that we highlighted that parties need to bring out in the amendment is whether we need to open our borders to Rwanda, Burundi, Uganda, and Tanzania for admission as an advocate. Further forward, we will see the various qualifications that the other countries, the 5 other countries, are now required. We also note that part of the ELS group of countries that compose the East Africa law are not included in this list because this list only includes Rwanda, Burundi, Uganda, and Tanzania. So we can move forward and then we'll cover the last bit on the recommendations. So on section 13, on the professional and academic qualifications, a person shall be duly qualified if, take me to the highlighted section. I think it's the 3rd slide. Please take me to the next slide, Wendy.
Is that the correct slide?
No, the one that is highlighted in red. If he's an advocate for the time being, of the High Court of Uganda, High Court of Rwanda, High Court of Burundi, or a High Court of Tanzania. So in this part of the act, we see that if you practice as an advocate in any of these courts, you qualify to be admitted as an advocate of the High Court of Kenya. We want to base that with the recent case of Martha Karua, where she was denied a chance to practice in Uganda, despite being an advocate in Kenya. One of the reasons why we propose for the change of this part of the law is that despite being an advocate of the High Court of Kenya, we are not able to practice unless granted the chance by the societies, law societies of other countries, as opposed to Kenya. For Kenya, you only need to be an advocate for the time being of the High Court of Kenya, or Uganda, or Rwanda, or Burundi, or Tanzania. Please take me to the next one. So if he is for the time being admitted as an advocate of the Superior Court of a country within the Commonwealth, and you have practiced as such in that country for a period of not less than 5 years, another requirement that is necessary for somebody to be admitted as an advocate of Kenya is if you have been admitted as an advocate in the Commonwealth and practiced for 5 years in the Commonwealth. That gives you the qualification to come and practice in Kenya. If we are basing it with the other jurisdictions, then we'll realize that in the other jurisdictions, for instance, if I was to go and become an advocate in a Commonwealth country or a solicitor, I would have to undergo their training and be qualified to practice as such. While in Kenya, our requirement is only that they have to have practiced in such a country for a period of not less than 5 years. So again, the provision there is that provided that the council may, in addition, require that such a person to whom this paragraph applies undergoes such training for a period of not exceeding 3 months. So this provision has 2 parts. Number 1 is that the council may, which is not mandatory, they may decide not to subject this person to a period of not exceeding 3 months, so that they can be trained as an advocate. If you compare that to the period that advocates in Kenya train to become advocates, I think it is a period of not less than 9 months in Kenya School of Law and 6 months in pupillage. So for this one, the requirement for a person who has practiced for not less than 5 years to come and become an advocate in Kenya is only that they may be an advocate, or if the council feels that there is an additional requirement, then they may undergo training for a period of not exceeding 3 months, which is different from what the requirement is for us citizens of Kenya. The next. The next slide is a senior counsel requirement. Under this part, a person is required to become a senior counsel if they have consistently worked for at a certain place for 15 years. So the first point is, when I'm waiting for you to take me to the part in red. Okay. The requirement is that you have to have consistently worked for 15 years in one, a continuous period of not less than 15 years. So the recommendation is to have people who have progressively worked to a cumulative of 15 years, not continuously, to also be able to submit their applications for senior counsel. So the recommendation then is that a person to whom Section 10 applies, that he holds or has held for a continuous period of not less than 15 years, be amended to he holds or has held for a cumulative period of not less than 15 years, one or other qualifications specified in Section 13.1. Section 10.1 provides for the provisions of an advocate, and therefore we submit that you do not need to have continuously practiced for 15 years to become a senior counsel. That is the proposal that we are making. The next part that we are going to is on section 34, which I want to tie with section 23 on the issue of practicing certificate to confer membership of the society. Section 23, part 2A states that the society shall issue to every advocate registered with a stamp or a seal bearing the advocate's name, admission number, and the year of practice in such form as may be approved by the council of the society and prescribed in regulations, and such stamp or seal shall be affixed on every document drawn by such advocate and lodged for registration in any registry in Kenya or issued for any other professional purpose. This section of the Act, ideally, is a lapse that befalls the society, because if the Act provides that every advocate shall be issued with a registered stamp or a seal bearing the advocate's name by the society, the issue of issuance of registered seals with the society would go a long way in curbing the issues that the Act talks about of advocates practicing who are not licensed or allowed to practice. So this section of the Act fails in actualization of this section, so that every advocate who practices does not only have a stamp, but has a stamp that is serialized by the society and that is allocated to a certain person, such that if the stamp of an advocate is used by another person who is not licensed to be an advocate or a masquerader, then that particular advocate may or can be held liable for having issued their stamp. So the actualization of this one is the part that is lacking in society. So we are proposing that the issue of practicing certificates and issuance of a stamp be added to it, a section to it, that allows that at the time that an advocate is being issued with a practicing certificate for the year, then we are all able to renew our stamps. And for those of us now who have, because the society has never issued our stamps, we can now start picking our stamps and working on the issue of masquerading by adding a section 2B or an addendum 2.1a on when the issuance of these stamps happen and actualizing it. The other bit that we wanted to tie with section 23 is section 34, which says that an unqualified person shall not prepare certain documents. And part of these documents, section F, is any document relating to any other legal proceeding. Section A all the way to section F. Section A talks about any document in relation to conveyancing of a property. Then section B talks about limited liability companies. Then section C talks about documents in partnerships. Section D talks about documents in grant of probate and letters of administration. Section 4 talks about a fee prescribed by the Chief Justice. The contentious section is section F, which talks about documents that unqualified persons should not draw, which are relating to any other legal proceedings. The proposal is there's been a Small Claims Act that has been passed that allows any other person who is not an advocate to be a representative of a person suing or being sued. So if the Act then states that an unqualified person, and an unqualified person in this instance is somebody who is not yet an advocate, cannot draw any document that relates to any other legal proceeding, I think it's either time we amend the Act to include the provisions of the small claims, either relating to any other legal proceedings except those provided for in the Small Claims Act, or it's time that we work on the Small Claims Act so that then it is only advocates and persons who are qualified that can draft and prepare documents or instruments that relate to legal proceedings. So the provision F either needs to be amended to include the current position, or the Act of the Small Claims needs to be looked at so that only advocates can represent in one way or another. Section 35 requires that instruments that are drawn should be endorsed by the name and the address of the drawer. The endorsement part requires the stamp that was provided for in section 23 to be endorsed to documents that are provided for in section 34. So the stamp that the society by law of this act is supposed to give an advocate is supposed to be endorsed to documents that unqualified persons cannot draw. And then those documents are supposed then to be presented in court. So the first instance is that if the stamp is lacking and then those documents, there's a qualification, then section 5 cannot be fully actualized in a manner that the act anticipated the same to be done. So that same section 35 also still provides that in case a document is drawn and the same is presented to court by somebody who is not qualified, then that person, section 34(1), shall be liable to a fine not exceeding 5,000 shillings in the case of an unqualified person. So the proposal is that the fine of 5,000 for drawing a document, if you're not qualified, that is also not endorsed by the name and address, is a little too low if we are really intent on curbing the issues of masquerading and the issues of people who are not legally allowed to draw documents, taking up the work of advocates and drawing documents. So the proposal is that section 35 be amended to a fine that is higher than 5,000, because 5,000 for drawing a document is too little if you are masquerading as an advocate or if you are representing somebody as an advocate without being an advocate. Then the second last section that we looked at is section 60 that talks about complaints against advocates. It requires that a complaint against an advocate for a professional misconduct, which includes disgraceful or a dishonorable conduct incompatible with the status of an advocate, may be made to the tribunal by any person. But that person, when making the affidavit, section 2, requires that every such fee shall be paid to the society and may be applied by the society to all or any of the objects of the society. The proposal is that if there's a complaint against an advocate, then there need not be a charge or a fee that is assigned to it, such that when I am reporting the misconduct of an advocate, be it an advocate reporting an advocate or a lay person reporting an advocate, that they are required to pay a fee to register that complaint with the society. If then that fee is supposed to be held, then it may hinder access to justice, because this is an advocate and ADC complaint. There really is not need for putting a fee to a recording of a complaint by an advocate. So I think those are the parts we looked at. So basically, just to sum it up, we looked at the conduct of an advocate and whether there's need to report and pay, whether the act provides for the stamp that is supposed to be given to an advocate and whether that stamp is being issued as is required to. The third thing is whether senior counsel can cumulatively and not continuously account for 15 years and apply to be senior counsel. The fourth thing is the effect of the requirements of the act, and especially the issue of stamps on practicing as a non-advocate and masquerading. And then the fifth thing, which is the most contentious issue, is section 34, that an unqualified person is not supposed to prepare a document that relates to a legal proceeding. So the act is either clashing with the Small Claims Act, or one of the two needs to be amended, depending on where advocates' bread and butter is coming from. So that is the position that we had on the amendment of the Advocates Act Cap 16. I see a question. I don't know whether it's mine, but I'll take it back to you, Wendy.
Thank you, Effie. Members, anyone with a comment, a question, a proposal? I can see your hand, Tyson. Let me allow you to speak. Please proceed, Tyson.
Hi, good afternoon.
Good afternoon.
I just have one issue of concern. There was an issue that the presenter discussed about the electronic, the stamps and the seals when advocates are drawing their pleadings. I just want to confirm and seek a clarity on whether these stamps are factoring in the new technology. Are we advancing to e-stamps or it's purely physical stamps? Kindly. And more so, my concern is on the electronic stamps because currently the judiciary has gone electronic via the CTS. So if LSK is to issue us with the stamps, does that factor in electronic stamps or it's purely physical stamps? Kindly, thank you.
Thank you, Tyson. Effie, do you have anything to respond to that?
Yes. Please take us back to the wording of the act. In to try and respond to Tyson, we have, as anticipated by the act, not gotten to where the society, that is the LSK, issues stamps to advocates as the act requires. So the proposal that we were making, because section 23(2) states that the society shall, which is mandatory, issue to every advocate registered with it a stamp or a seal bearing the advocate's name, admission number, and the year of practice in such form as may be approved by the council of the society and prescribed in the regulations. So if we are to ever even get to the point where you are proposing that we have an e-stamp, we have to first actualize the need that the act provides that the society gives advocate stamps for a reason. So that then we are saying if the society gives advocate stamps, then can it give us the e-stamp and the physical stamp for as and when each is needed? So, and I think in advancing with technology, because we have gone virtual on courts and almost all our transactions, it would make sense to have your proposal that we give e-stamps, but it also does make sense that an advocate has a physical stamp. And the act as anticipates that if it anticipates that that stamp also has to bear the year of practice, then that means that every year, every advocate has a new stamp that indicates my practice number and practice year. Like the number always changes when you take out your PC. So it is a good proposal to have an e-stamp, like you proposed, Tyson, but we also just need to on the side have the act as it wants us to put an amendment that the society now shall mandatory provide the stamp. So that then we are saying give us the two stamps, the physical one and the e-stamp for ease of practice. So yes, I agree with you, Tyson, that we need to get there for both. I hope I have attempted to answer your question.
Yes. That is not thank you.
Thank you.
Frank Walukwe, I can see your hand is up. Please unmute.
Thank you very much. As regards this issue of stamps, how efficacious is this suggestion going forward? You know, we must take into consideration that there was a time when there were only 1,000 advocates in the profession. And so a suggestion that the society will give stamps to advocates would make sense. In a situation where we have 20,000 plus advocates and growing, how efficient do we even think LSK can be with issuing stamps every year? Especially taking into consideration, if I remember correctly, that the purpose of giving practice numbers emanated from the fact that they could not keep up with this suggestion of giving stamps. And also taking into consideration just the design and outfit of it all. I probably prefer red, my stamps being in red and being circular. So if I was to be issued with rectangular small stamps by LSK, I'd probably choose not to use it. So does it even make sense for us to continue having such a provision in the law? Going forward, I think if we want to deal with the issue of quacks, we'll just have to raise awareness. We just have to find a way to raise awareness so that it is commonfold that if you go to an advocate, first and foremost, do a search. That is the reason why the search engine was created, so that we deal with that. Thank you.
Thank you, Frank. I heard you talk about your preference, and knowing you, I think the stamps that will be issued will not be to your specification. But be that as it may, I think that section is it's a contentious section that is in the Act and is mandatory in the Act. So unless the members, again, like you're saying, would want to say that the society cannot practically act as is in the Act, then let's do away with it. So then we have no requirement of the society. The flip side would be then that if we do not pass an amendment that they cannot do this, it's not practicable to remove it, let it remain, then we have to actualize it. So it's either or, depending on how the members generally would feel about what is in the Act. But as at now, as is in the Act, that is the mandatory requirement in the Act. So if we will feel today that is requiring too much of the society and they can't do it, we're still the members we can amend and remove that, entirely remove that section.
Any other comments? There seems to be no other. So we can move on to, okay, I see someone in the chat section. Rose Kariuki. Number one, please guide on the issue of naming of law firms. That is, could it be opened up creativity and initials for sole proprietors too? Number two, could we please allow a law firm, sole proprietors and partners to have the option of operating as a company limited too? Effie?
Ross, if I get you, I think I don't know whether your question one applies to the Act or the rules, but let me attempt question two. Could you please allow law firm sole proprietors and partners? So could we have law firm partners to have the option of operating as a company limited too? So is the anticipation then that a company, say FE and Company Limited, would it be limited to practicing as an advocate or to what scope? Because a company limited only acts as per the memorandum. So, and articles. So, do you anticipate that a company limited would be a covering company that includes a law firm and other companies? Or do you want that it's AFN Company Limited solely for providing legal services? That is the part I in your question that is not so clear. And if you can just solely for legal services as opposed to in company. I don't know. I don't know why the limited part would be there. I don't know. Maybe we can hear the members' view.
Effie, I'm sorry to interrupt you, but I can see she's raised up her hand. Let me just allow her
Okay.
to.
Okay.
Rose, you can unmute.
Hi, everyone, and thank you for the chance to address you. My concern is law firms, when we start off as sole proprietors. We grow, but we are basically giving legal services, and our issues, like currently, we are facing challenges with KRA, because unless you're a partner, you will not get a separate PIN from your individual PIN, and at times you don't have a partner. So can we be allowed to have the law firms run as limited companies solely for the provision of legal services? And yes, we could still go through the processes of opening a law firm in terms of LSK being approving the company limited and stuff like that, but could that be opened up? And then on the first question on naming of law firms, we note that yes, we have the naming of law firms, but we have become so many so that you will find karaoke's are many. So how do you differentiate which karaoke? Could we open it up to some creativity? Even as partnerships are enjoying the initials, sole proprietors are not able to enjoy the creativity that comes with initials or any other namings. That will be my contribution. Thank you very much.
Okay. I think from where I sit, and somebody is also free to weigh in. There are very many names that we could use, but if we open it up to initials, then it would even get, if the point you're saying is that there's Karanja, Mercy, and Karanja Otieno, and so if I say Karanja and Company, which Karanja am I referring to? Then your proposal to have initials, which is not allowed currently by the society, would not ease it, because then it would be K and Co for ease of identification. Then how do I then say K and Co now refers to that Karanja? How does that make it easy as opposed to Karanja and Company, for instance? How does initials ease identification if that is what we want to cure, as opposed to having a different name to the name that is perhaps used by everybody else?
It would still save a whole lot, because the other time we're doing a search for law firm, opening a law firm, and would start with let's say WK, and you'd find there are so many WKs, right? So that if we could, when I say creativity, if we could sit and agree on how to model it, that you're not only just relying on WK law firms or a law firm, and you find if you're searching for WK, you're finding like it's not available because it's been taken by so many other people. And if you want to just stay with the name of the farm, let's say now I have Wandia Karaoke, There are other Wandia karaoke's. So could we work on opening up the naming of law firms, even for the sole proprietors? Because I find for partnerships, we're able to manage and we're able to be creative with the initials and come up with something interesting and capturing. But for law firms, if you are not putting your name, then you don't have any other way of identifying yourself. That is where I'm coming from. So I might not have the whole process of how we can go about it now, but could we open up that discussion? All right. Because we are finding it a challenge, especially now, even with the upcoming law firms, to find names that have not been taken up and that can still be uniquely identified to an individual. Thank you.
Any reaction to comments by Advocate Rose?
When I see one comment on the chat, if you can, I don't know whether Sine, you want to weigh in, Janet or Thero. I know that's perhaps your fault. You can give us a little bit of insight.
I have also enabled Janet to speak. If you'd like to weigh in.
Sorry, I was just typing in while I was in a meeting, but just a few minutes. How BRS is functioning nowadays is that they've sort of merged their entire database, touching on companies, business names, as well as LLPs. So if you're going to be doing a search for a law firm name, you're going up an existing database of companies, 1 million or 100,000 other companies, LLPs, and business names. So if there's a way that law firms can be segmented through, I don't know if that's possible, because that's telling the government to bend to our whims. And if that is not possible, then I think it's for now the Law Society to be able to panga its members in terms of namings, because I can tell you what Rose is saying. Even looking for a name last year, it took us 2 months of going through the database back and forth, putting all sorts of acronyms, letters, names, initials, everything. And it was not easy. I can tell you it was not easy because nothing is just available on that particular database. So going forward, this is just 2025 and we were struggling like that. In another 2 or 3 years, everybody will be opening their own law firm, will be admitting more advocates out here in practice. So if Janet Otero runs out, or if Rose Kariuki or some of the more common names run out, then what are we left with if BRS is not able to accept the traditional names or the traditional initials as we know it? So that's something for the task force or for the committee to consider in terms of naming culture.
Thank you, Janet. I think that is an important contribution, but maybe just to help members, there is a proposal that is work in progress between LSK and BRS to have a way through which we are able to segment so that at any given time we have a view of the number of law firms that have been registered and the number of law firms that are operating. So maybe once that has been put into place, some of these challenges will be taken care of. But I agree that indeed these are matters that we need to consider and think about for the future. Asante, sir.
Thank you, Chair. Just to confirm, before we move on to the next presentation, is there anyone else with a comment? or a question about the Advocates Act and any proposed changes? Oh, okay, I can see. Rose, is this a legacy hand, or would you like to speak again?
I would request to speak again. My contribution was on two fronts, and I hope the second front has also been taken note of, because it's a real issue in the practice currently. And I hope I've been clear on it. If there is any clarification needed, you can let me know.
Your point was clear. We've noted that down. So we will collect the comments even as we prepare the report to share with National Office.
Thank you very much.
Okay, so our next presentation will be from Muthoni Gashara. She will be handling the advocate practice rules. Muthoni?
Thank you, Wendy. Thank you, members. So I'm tackling the advocates practice rules of 1967, which are under Section 87 of the Advocates Act. They are pretty small. They're just 12 rules. And these rules, the core principles of the rules are professional integrity, client protection, no touting or advertising, fair competition, and proper billing and fees. The rules, there are just like 3 rules which felt like they needed amendment, or that a recommendation for amendment. And one of them is Rule 2. It provides that no advocate may directly or indirectly apply for or seek instructions for professional business or do or permit in the carrying on of his practice any act or thing which can be reasonably regarded as touting or advertising or as calculated to attract business unfairly. When Noyo was dealing with the marketing, he tackled the aspect of advertising, and the same is provided in these rules. So you'll see that there is vagueness in the modern terms, because what counts for advertising, we have social media now, and looking at these rules being for 1967, I'm sure there have been amendments, but there is no definition of the word advertising which puts regard to our current circumstances. And so the proposed amendment to that would be to define the word advertising and solicitation and what is touting, to include the digital and online advertising, because you see we have websites, we have social media, we have people are doing adverts on Facebook, they are doing it on Instagram, TikTok, on X. So there needs to be a clear definition of it, and maybe also look at are there going to be penalties, so that in case there are any misleading or false online advertisement, and just basically allow the advertising define it, and also but just also have the limit, let them be clear. The other rule is Rule 9, which provides for coaching or permitting coaching of witness. It provides that no advocate may coach or permit the coaching of any witness in the evidence he will or may give before any court, tribunal, or arbitrator. So this is useful, but again, it's a bit vague. What counts to coaching? There is no express rule on the digital communications, and therefore we would recommend that there is a definition for coaching. It's more precise. does it go to in rehearsing the answers, correction? What is this coaching all about? So that, I mean, it needs to come out clearly. And then there's Rule 12. Rule 12 provides that the Council of the Law Society of Kenya shall have power to waive in any writing of any provision of these rules in any particular case. And so, fine, this is a very good flexibility, but then the same, in our view, it lacks criteria for waiver, and it's a bit opaque. And so the recommendation would be at least to provide an explicit criteria or guidance for when this waiver is appropriate, and also require written reasons and why would there be a waiver in a certain aspect. Yes, and just to see that again, like Oyo was talking about, the ones he was saying for 1990, this is 1967. And as much as we have the amendments and the latest one being 31st December 2022, there needs to be, we are in an era of technology. These are virtual hearings, so they need to be reviewed for modernization of the same. Yeah. That is all. Like I said when I started, it's a bit short. Can open up for comments and any recommendation from members. Wendy, maybe you can proceed.
Muthoni, would you like to take maybe comments?
Yes, as I was saying, are there any comments, any recommendation, any input?
I can see in the chat section, Yvonne has typed, what happens if a person issues a demand letter using an advocate's firm name and even the advocate's personal number without authority? What would be the proper professional response? Would such conduct give rise to any enforceable legal claim, or should it be addressed purely as a professional or disciplinary matter with the client?
I think Yvonne, you must be referring to rule number 11, which provides that no advocate may request in a demand before action payment from any person other than his client or any cost chargeable by him to his client in respect of such demand before action and in respect of professional services connected to this. Maybe Wendy, could you just let her speak? Is it a comment or is it an input? Just allow her to speak up.
Yvonne, you can unmute.
Good afternoon. It's a question more that to enlighten. It's an ongoing thing that we've received. Someone shared a demand with our name and my personal number, and we have no instructions from SID. In context of the SID. Thank you.
So what happens if a person issues a demand letter using an advocate's firm? So from where I see it, I feel it's definitely a professional misconduct, and I think you can first you can tell them to cease and desist. You can also, I mean, on a higher scale, you decide to either report it to the advocates disciplinary tribunal, because that's pure misconduct, especially if the person is an advocate. So, but I think maybe chair, my seniors in the platform, you can make your comments on the same. So I have seniors here. I have Frank, Janet. Could you maybe weigh in on that question? Or chair, based on your expertise and your ears.
Yes, Rose.
The question would be, was the person who was issuing the demand letter an advocate in the first place? Because if it's an advocate, yes, it would fall under professional a professional issue and a disciplinary matter against that advocate. But also from my stand, also it could also be a criminal matter, because that is impersonification. So they can take both ways. As if the person is an advocate, it can go through the, okay, if it's not an advocate, go through a criminal process. Go through a criminal process, because they are actually now impersonating you as the advocate. That would be my take on it.
Yeah, I agree with you, Senior. Thank you. Any more questions, comments, input? Over to you, Wendy. Thank you.
Chair, are you saying something? I can see you're not muted. I'm not sure if it's an issue with your audio.
I think there must be an issue with my audio, because I was trying to answer Yvonne's question, but Ross has tackled it very well.
Okay. Any other question, members, or comment? Okay. So if there's none, then I'd like to invite the Mount Kenya branch team to present on the Advocates Act and the Law Society of Kenya Act and Law Society of Kenya General Regulations 2020. So we can start with Margaret, who will go through the LSK Act 2014. Margaret, if you can hear me.
Yes, good afternoon.
Okay, good afternoon.
I'm audible?
Yes, we can hear you.
Okay, thank you. Yes, I'm going to tackle the Law Society of Kenya Act. It's basically an act which was made to consolidate the laws relating to advocates. Some of the issues identified are, number one, the issue of the anti-money laundering. Currently, the LSK is limited in its supervisory or regulatory capacity under the anti-money laundering laws, where lawyers are plastered as reporting agents. And LSK lacks powers for enforcement and or inspection. The proposed amendment then would be amending the LSK Act to explicitly grant the LSK powers to supervise, inspect, and enforce compliance. This will go a whole way in ensuring at least Kenya meets the international obligations It's going to prevent oversight gaps and hold advocates to ethical financial standards, which will prevent financial crimes. The second issue would be protection of advocates in performance of their duties. There have been complaints of advocates sometimes being arrested or harassed in performance of their professional duties, and the lack of the advocate-client privilege or the advocate-client privilege is not always respected. There would be a proposal that there be an express, an insertion of an express, to insert an express clause on the LSK Act to restrain the arrest or detention of advocates while acting in their professional capacity, except under lawful process, that to ensure that there are forums to raise complaints, clarify the privilege under which they are protected, and ensure that their work is not hindered. This will go to safeguard advocates' independence, ensure rule of law, protect their clients, and protect their clients. Number 3 would be transparency, financial management, and audit. There have been allegations previously on mismanagement of funds, lacking clear financial reporting to membership, or weak internal accountability. The reforms would be to require annual external audit and publication of LSK financial statements, and probably require periodic member reporting, or maybe establish a financial oversight subcommittee, or maybe a member-driven audit mechanism. It's just a proposal, so as to build trust among members, increase accountability, prevent the misuse of resources, and also enhance legitimacy of LSK leadership action. Lastly, there is the issue of member participation, governance, and natural justice. There have previously been disputes over quorum, notice, proper access to meetings, SGMs. You all remember the Harvey 2021 SGM. We therefore need to amend to strengthen the rules for meetings. There be clearer notice periods, election and or voting rights rules, the rights of advocates to call meetings, the right to challenge council decisions, probably explicit natural justice requirements in LSK decisions. That's to do with disciplinary and governance.
Margaret, we cannot hear you. Chair, you're saying something? Margaret?
Sorry, am I still audible?
We can hear you now.
Okay. Where did you lose me? I'll just go over again about member participation, governance, and natural justice. Previously, there have been disputes on quorum, notices, proper process of meetings, SGMs, etc. Members' rights to information and participation. There would be a need to reform this so that we amend to strengthen the rules for meetings. There be clearer notice periods, election voting and or voting rules, the rights of advocates to call meetings, the rights to challenge council. And this will ensure fairness, which will avoid arbitrary decisions and hopefully enhance legitimacy of LSK decisions and reduce internal conflict. Those are the areas that we have identified. Back to you, Wendy, if there is any question or clarification.
Thank you, Margaret. I can see 2 comments. So we have one from Sharon. In case I have instructions to draft a client's document, the client is acting in person. Should the documents read drawn and filed by my name, yet I don't have a firm registered in my name or the client's name? Kindly clarify. Then we have a comment from Ben Sihanya, Professor Sihanya. Sessions like this are crucial for all of us advocates, whether young, mid-bar, or elder. Thank you. Due to numerous developments, at least 3 times a year would be great. Blessings. Any further interactions with what Margaret has presented? Thank you, Professor Sihanya. And maybe Margaret, you can also see if you can answer Sharon on the issue of clarifying whether the documents should read drawn and filed by her name if she does not have a firm registered yet.
Thank you, Wendy. I think that question was directed towards the Advocates Act, but I could try and answer that. In my experience, what I've seen, if an advocate has not registered a business name, they're practicing in their name. So the document should be drawn and filed by them in their name, Margaret Kimani, advocate. And like when I've registered a business name or a company name, where it would be Margaret Kimani and Company, advocate. That would be my response. Maybe there could be an additional input from the others. Thank you.
Any question, members, please feel free to raise your hand. You'll be unmuted to speak. Okay, I see one hand up. Sandra, you can unmute.
Thank you, Wendy. My contribution is on the question that Sharon has raised. When I've read that question, my understanding is that she's saying that the client is acting in person. My understanding is that she's trying to assist that client to draft the document. So because of that, I had thought that because she's only assisting, the documents could bear the name of whoever the client is. That's how I understood the question that she has asked. Apart from that, thank you for the session. It's very informative. Thank you to everyone.
Thank you, Sandra. Yes, if a client is acting in person, the document should be drawn by the client's name. Even if you're assisting, you're just assisting them to draw the documents, but if you've not come on record as an advocate, the document essentially should be drawn by them. Thank you.
Okay, thank you. I hear you, Margaret. Thank you.
Thank you both. I see a hand up, Mary. Okay, you've lowered your hand. Okay. Thank you, Lydia, for answering in the chat section. She says, once admitted, an advocate can draw documents in the individual names. If you haven't been formally retained by a client, you can do the documents in their names. I think that is well answered. So if there's no other question, we need to move on to the last presentation, which will be done by Hiram Kirimi of Mount Kenya on the LSK General Regulations 2020. Hiram?
Yes, I'm present. Am I loud enough? Am I clear?
Yes, we can hear you. Please proceed.
All right. My name is Hiram Kirimi, Treasurer Mount Kenya branch. I was tasked with discussing the proposed amendments on the general regulations of the LSK General Regulations 2020. A brief background is that the regulations were recently amended. They are 2020. They are quite recent. They were promulgated under the LSK Act number 21 of 2014, basically to guide on governance, operations, and affairs of the society. The regulations address critical areas such as membership, elections, finances, general meetings, CPDs, and disciplinary procedures. There was no draft present, so I took it upon myself maybe to just go through the regulations and come up with propose some amendments. I proposed some amendments, which I will quickly go through owing to time constraints. There was the issue of transparency and accountability. I will start with that one. On transparency and accountability, the current position as it stands, the regulation number 71 provides for accounts and audits, but does not mandate real-time disclosure to members. I was looking at this section and I was thinking, why wouldn't we be having quarterly financial reports published by the council and branches to its members just for transparency? So I think if you could have an amendment to this regulation, we could have a disclosure of the procurements and maybe some of the contracts that are carried out by the council. So if we could be having quarterly reports, they could be, I know someone would ask whether there will be enough time to audit and actually publish these reports. My thinking would be just to have, even if we could have an audited report, just have what is in the bank vis-a-vis what they have used to run their affairs at the council. This will really help members to maybe be in touch with what is going on. You'll find that the transparency builds the currency and the trust between the council and members. So it will hold the council more accountable. The other issue was on disciplinary processes. This is as it stands, we do not have a regulation on this. Remember that this is the general regulations that guide the LSK. As it stands, we have the advocates. Disciplinary committee or tribunal rather, where we find that minor disagreements between advocates and their clients may be I find that maybe for us who are practicing in our country, the clients have to go all the way to Nairobi just to report their issues there. I was thinking maybe if we could have some processes at the branch level where we could have the branch could receive and attempt to settle these minor grievances. Maybe the communication breakdown between the clients and advocates, and then which can be handled just to fast track and maybe to reduce the backlog at the ADT. If we could have a mechanism just at the branch level, because we find it a bit difficult. Once we get complaints here at the branch level here in the upcountry, we almost have to guide them just to report all the way to Nairobi at the ADT. I know a question will arise on whether that would duplicate the functions of the ADT. The proposal, the regulation, maybe could just the branch level to handle these minor grievances, where maybe the branch will find that there was professional misconduct by an advocate. That is when that issue will be escalated to the ADT. But where maybe the issues are minor, that can be handled at the branch level. There was another issue where I found that will need some amendment, or rather our inputs. It's on the welfare of members. You'll find that what guides the welfare of members as it stands is the ABA, which is voluntary and external. I was looking at the regulations and I was thinking maybe if we could come up with a provision just to have to establish branch level welfare schemes to support membership welfare by each member maybe contributing some amount, as opposed to having the ABA come in, because you'll find that the ABA will be a bit slow in reacting, right? Maybe when a member is hospitalized or there's a member who's bereaved. I was thinking if we could have this welfare entrenched in the branches, where members can pay up some fee, and then this fee, now maybe a member is admitted to the hospital, we have that member taken care of from the kitty, and I believe that this will ensure that the members are taken care of at the branch level. In as much as the society stands with its members, we cannot outsource the welfare, right? So the society must stand with its members, and in as much as ABA is important and helps the members of the LSK, we need to have a targeted assistance. So I was thinking maybe if we could have a members' welfare entrenched in the regulations. The other issue, and which I think and I believe will be thorny, is the issue on the devolution of funds to the branches. You'll find that from the regulations as it stands, the formula in disbursements of these funds is entrenched under the third schedule, which generally provides that a branch shall receive a basic allocation from the society, a flat rate. This is just for administration purposes. And from time to time, additional funds may be allocated to the branches based on the membership size of the branch. you'll find that this formula, it is upon council to decide on what each branch gets from HQ. I was thinking if we could have something, maybe a regulation in this in our regulations, the LSK regulations, we could have a formula as on how to have this money disbursed to its members, maybe to the branches. I was looking at it and I was thinking maybe if each branch could receive 40% of the annual subscriptions collected from its members, this becomes maybe having it as an automatic remittance, and then which will ensure basically that members from each branch will receive a proportional funding. On activity-based allocation, maybe 10% of the CPD revenues generated from the events will be withheld at the branch, right? So that now to maybe call it an incentives to branches to host these CPDs. You find that when CPDs are being held at the branch level, the show up by members is quite low. So maybe if there's that incentive that 10% of the CPD revenue to remain at the branch level, I believe this would act as an incentive just to have members show up for the CPDs. And also on the, maybe you could also have an equalization fund. Maybe 5% of the total LSK revenues can be distributed to branches with fewer members, just to equalize, to make sure that all regions are catered for, and that maybe the smaller branches can remain active and viable. So maybe I will suggest or propose, okay, depending if members approve, have maybe 5% equalization funds on the total of the LSK revenues. This will actually give branches a predictable and equitable funding while maintaining the council's central oversight. Also, with this kind of funding, for example, our branch, we have started a journey to purchase some piece of land. Now you'll find that once the allocation comes in from the main council, from HQ, it is difficult because we also have activities to run. So I believe once we have these proposals on funding, members can be in a position to plan on activities to undertake, whether it is developmental activities, activities to maybe some administrative activities. There will be certainty on what activities to take, because you find this money that is coming from HQ, you have to, if you're undertaking a program or an activity, you really have to write letters just to request for additional funding. So there is no predictability on whether a project will actually be successful or not. And also there's a challenge of going back to the members, asking them for more money. Of course, it will be a thorny issue because they'll say, hey, we are paying for our PCs, get that money from the HQ. So I believe if we have something entrenched on how to devolve these funds, we can be in a better position as branches to help us manage our diaries on activities that we'll be able to undertake or not in a year. And also, I was looking at, there was the issue of elections. I was looking at Regulation 59 to 63 that govern on elections. Well, so far so good. We have adopted the electronic way of actually conducting our elections. However, maybe we could have something added on, like having an independent audit of the e-voting systems. And also maybe just before a run up to the elections, we could have mock elections test before the voting, just to make sure that if the systems are up and running and that we do not find ourselves in difficult positions of maybe nullifying the elections or postponing them. So maybe this is just minor, just to have a mock-up, a test before the voting and providing independent audits of the e-voting. That was the amendment to regulation number 61. Unless other members have proposals on any amendments or add-ons, or maybe just to brainstorm on what I have presented on, that will be all from my end.
Thank you, Hiram. I can see there's a hand up from Senior Kasoa. Senior, you can unmute.
Thank you, Wendy. Hello, good afternoon, members. You can hear me?
Yes, we can hear you. Good afternoon, Senior.
Yes.
Good afternoon.
Yes, thank you, Hiram. You have done justice to most of the things that I thought of, but I can add something small. Yes, now I totally agree with you on quarterly finance, programmatic finance reports. My proposal would be let LSK learn from the national budget or county budgeting process. The budgeting process has a lifeline with various deliverables, which begins in September and ends in June with the Financial Act. So I'm thinking we can copy from what is working in our country. It's not perfect. We can perfect it so that members at the branches can be involved. After all our members are in branches, whether you are in Nairobi, Nini, it is all members can interact with LSK budget, and so that the council budgets on what members want as their priorities. For instance, in Nairobi, our priority would be on practice and registries, both the Ardhi Sasa and the court registries virtual. That might not be the same thing for Kakamega or for Meru, because probably they're not having Ardhi Sasa challenges. So that it is important for everybody to participate. And then you know which branch, what their priorities are, even as you allocate now the entire cake. Because Nairobi has different priorities from Garissa and all that. Number two, we have a finance and budget committee, which doesn't seem to interact with the members, neither does it not interact with branches. This needs to change. We need to put to them a provision on that budget committee of LSK that it needs to undertake the financial programmatic planning for the entire LSK. And I look at this finance and budget committee like the CRA, because of the challenges of the two levels of government. Sometimes the council behaves as though it's the prefect of the branches, and then it brings a problem. So the CRA, the Commission of Revenue Allocation, is the one which shares revenue. And I was privileged to sit in the council of 2014, and I'm one of the proponents of the budget committee, so that they can rationalize then the budget between the central organ, which is the National Council, and the branches. So they need to do the financial budget and also financial reporting on a quarterly basis. That is what I would add on your point. I'm just adding on it. Then on reviews, I would like to propose that we put in the regulation a requirement for the council to implement the AGM resolutions and report on the status of implementation, just like Parliament reports or JSC reports on the status of justice, or the Ministry of Environment reports on the status of the environment. The Council needs to report on the status of implementation of the AGM resolutions per quarter, and the branches need to also report on the status of implementation of AGM resolutions and annual conference resolutions. We have very many good resolutions in our AGM and in our council, but we never know. They just pile up. It's like a talking workshop. Because in 2018, I moved a motion for mid-year review of all council performance with our representatives who sit in JSC and other statutory bodies to report to us so that we can tell them our pain points and how they can improve. That motion went through, but the council has never undertaken a mid-year review. The few times I've asked, I've been told, oh, members, oh, unataka members watuingilie ABCD nini nini. My view is that when you are a leader, you must always be ready to be questioned. The moment you just take leadership like this, you become a respondent. And the more you report, the more members know there's nothing to be hidden. So you just begin somewhere. I want to agree with you that some complaints can be undertaken at the branches. We just need to have a structure of complaint review. And I do not think there's a big complaint and a smaller complaint. In my view, all complaints can be handled if the parties are willing. And where they are not willing, they cannot be compelled, they can be referred. But we need to introduce a complaint filing small fee, like 200 shillings, so that we just discourage frivolous complaints. And the branch complaints committee, not that they will be paid, but when they sit, they'll drink water, they'll take tea. So that 200, so that it doesn't strain again, the branches not to call for meetings, because there is even no coffee or tea. Now to the big one, the devolution fund. I like what you have talked about, the devolution fund. I may not have understood everything, but my proposal is that we need to come up with an interbranch, serious task force, but not governed by the Law Society, the National Council, but spearhead by the branch committee on finance. How are you? Spearhead by the finance committee for the reasons that I said, so that the council can also bring their views. We bring our views. But my proposal is this: services are to human beings. We may have started with distance and all those things, but I would want to request that 70% of the money that we put in the devolution need to go to the human beings who need to be served. The current formula works well for branches who do not have a lot of members, but it is an extreme disadvantage to Nairobi, and Nairobi is simply not able to meet its requirements to members. And we never do things going behind. Not that the branch should lose whatever they are getting, any other branch, whether Mount Kenya or Western or Coast, but what would be the cost analysis to deliver a service in Nairobi for a member, deliver a service for a member in Garissa or in Mombasa, so that we're a bit more realistic in the way we are doing this devolution. I'm happy you've talked about the practice fund. I had actually prepared a motion on practice and CPD, because currently there's a lot of duplicity between the national office and the branches, so that most of the money which would go to practice is duplicated, and therefore the branches don't have. So I would go that 50% of the practice money go to practice per member, because practice is per member. There's no need of a member paying for practice fee and they are complaining from morning to evening about Ardesasa, about virtual platforms failing, and we can't even employ a clerk to just be our liaison person at Ardhi Sasa in court or things like that. And I believe even the branches would require a liaison person, because even governors, they have their own COG. I would propose that apart from the branch caucus, we introduce an interbranch summit, like the one which is under the Intergovernmental Relations Committee, where all council members of branches, together with the National Council and the chairman of the branches, have a summit and discuss the state of administration of justice from the perspective of lawyers. I hope this is an amendment which can go through. I believe, Wendy, you're recording some of the discussion, so nothing will be lost. So to finalize, I would just want to talk about representation. I'm very passionate about representation, and I feel we don't get enough from our statutory representation. My view is that if I represent the Law Society on the energy IPRA today, my role should be to promote rule of law in IPRA and look for opportunities for lawyers, either as consultants, advisors, litigators in IPRA. So I would propose that we introduce TORs for all LSK representatives, who should then give us quarterly reports on the status of implementation of the TORs, and then we have a mid-year review with them. The reason why we can't meet them during the AGM is because the AGM is overloaded, so probably we need to introduce a mid-year review in October so that we can go through that. And then finally, the state of representation of LSK and the in-house practice. On the state of representation, I'm proposing that we go the bar way. Representation regionally has not yielded any fruits. So I'm thinking we go the bar way: young bar 2 reps, mid bar 2 reps, senior bar 2 reps of by gender, opposite gender. Then we retain the upcountry 4 members. Cost 1 member. We introduce an in-house council member, and then we have also a special seat from our colleagues who have special challenges, and then of course the chair and the vice chair. I think this will be more representative rather than fighting, like if I'm representing Nairobi and I empower Nairobi in the next elections, this person will be more, have more impact than me, so that we can deal with that. And then we also introduce TORs for council members to avoid this issue of a campaign manifesto, which you can never even implement, because as long as your colleague is not supporting you, your agenda will not go through. So that it's the members giving the council the agenda, the way we give the agenda through public participation in the Finance Act. And that is then what Parliament and the government will implement. The final one is on the legal departments in state corporations, that we need to define what is a legal department in the Advocates Act, and we need to define what are the bare minimums for a legal counsel and what are the bare minimums for somebody to do legal audit. It is not right for an accountant to do legal audit. It is not right for a human resource officer to do legal audit. Unless you have a practicing certificate, then you should be charged for masquerading to do legal audit. Thank you very much, colleagues. That is all, Wendy.
Thank you, Senior. Any reaction to what Senior has presented, or Hiram? You can raise your hand or type in the chat section. There seems to be no further reaction to the presentations. I'll just give it 1 more minute. And if there's
Only
none,
sometimes you can just call out names which you can see on the screen to activate a reaction.
so from the list of names in the order that is on my screen, we also have our council member and treasurer, Irene Kiwul, present. You can say something. Sandra has spoken, Tyson, Oyo, Yvonne, Alice, Annbeth, Professor Sihanya, I know you typed in the chat section, Brian, Cecilia, Christine. Irene, are you on call?
Yes. Good afternoon, colleagues and fellow members. It's my pleasure to meet you this afternoon. I think I would like to really appreciate my fellow council members and the branch for having been able to have the members come together to take us through the proposed amendments to the Advocates Act. And I love the proposal that we should have more initiatives of reviews of our legislation that affect us as advocates. And I think we'll take it up as the council to continue this initiative. And of course, the collaborations that we are having with our branch, our other fellow branches and the council members. Thank you so much for this presentation to all the members. Thank you for the attendance. Always a pleasure to be of service.
Thank you so much, Irene. If there's no reaction, then please allow me. Okay, I see a hand up. Before we move on. Okay, the hand has gone down. So please allow me to, okay, it's back again. Yvonne, is that you? Okay. Please allow me to bring this session to a close. We will compile all the feedback received for onward transmission to LSK National Office. I would like to invite one of our council members or council members from Mount Kenya to just give a vote of thanks. From our side, we thank all participants and your feedback, and we hope we can do more of such as advised by Senior and Professor Sihanya moving forward. So is there any volunteer from our side or Mount Kenya to give a vote of thanks? And we bring this to a close. You can raise your hand. Margaret, Hiram, Chair.
I think Wallace should be on the platform. Is Wallace
Wallace?
present, I think?
Wallace? Yes. Wallace, you can unmute.
Yes, can you hear me? Good afternoon, colleagues.
Good afternoon.
Yes, my name is Wallace. I serve as the representative from Orang Advocates to the council. Yes, I want to, first of all, to thank both chairs, Chair Kevuva and Chair Joel for the effort to bring us together and also to assist us in deliberations that we've just made. They are progressive in terms of progressing advocates practicing space. And in the circumstance, I think this will go far much ahead, as Professor Sihanya has told us in the chat, that these kind of discussions and discourse are very important. And in fact, he even proposes that they should be done as frequent as 3 times per year. In the circumstance, I want to also thank both the council members from both Mount Kenya and also from Nairobi for their cooperation. Thank you, even our the persons who are advocates who presented these particular acts and discussed them in the manner that they did. We thank you, and also for participants, want to thank you for your input. Thank you to everyone. Thank you for this opportunity. We hope to do this much more and quite a frequent times, so that we can work for the betterment of all the advocates. Thank you very much and have a lovely evening.
Thank you, Wallace. We bring this to a close. Thank you, Council Nairobi Branch and Mount Kenya. Have a great evening. And in case you need to share written comments, please send to info@lsknairobi.org. I will just type that before you leave. info@lsknairobi.org. And I will end the meeting. Thank you. Bye.
Thank you, colleagues. Goodbye.